Hello, my name is Dr. Jackalyn Rainosek, and I'm with DTP-Leadership Group. And I have a wonderful attorney with me today that's a dear friend, Richard Wilson. Now, he's going to answer all the legal questions because I am certainly not that, but I will be able to add some things that I think will be important for all of our listeners. So what I want to say though, this is hot topic, bold talk. So we do our best to be very clear about when we look at cases, to not only present to you what the case is about generally, and then to give you some legal understanding of what's going on so you can be much more aware of what the Supreme Court is going to do in certain cases. Because I think we have been too long not paying attention to the Supreme Court, and lots of things are changing. Now, we shall see what happens in this case because Richard is certainly much more knowledgeable about it than I am. But I am someone that I would say is a protector of the environment. It's very important to me. And yet I have a lot of friends that are in all companies, so I can also understand some of their concerns. So, Richard, I want to start. I think my listeners, I brought this case to you. But I think my
You did.
listeners need to understand what this case is about and the reason we want to even have them listen about it. Okay? So it's your turn.
Okay. And first off, because our discussion of what the case is about will eventually devolve into um, the dissection of the English language, I do want to tell your listeners that yes, I too agree that the term wonderful attorney is probably an oxymoron. Um, Now, having said that, the case you're talking about is the Chevron v. Plaquemines Parish, which you brought to my attention after it had been brought to your attention because of the potential environmental effects that a decision on the case could have. But the particular question on the case concerns something in courts that is referred to as subject matter jurisdiction. In courts, you have two types of jurisdiction. One is personal jurisdiction, and the idea behind that is if someone is going to sue me, they have to sue me where you can find my person down here in South Texas, as opposed to suing me up in Anchorage, Alaska. That's the personal jurisdiction standpoint. But the other jurisdictional issue is what's called subject matter jurisdiction. And the idea behind subject matter jurisdiction is there are different courts in the country. If I have a particular dispute, and we're focusing here on civil cases, which are cases basically about money as opposed to criminal cases. If I have a dispute about money, in what court do I bring that suit? And
Mhm.
that is the subject matter jurisdiction issue. And most cases, and I can tell you most of the cases in my practice, end up in state court because most disputes concerning money involve issues that are state law. So the majority of lawsuits end up in state court. That is one area of subject matter jurisdiction. But there are some cases that, because of the subject matter, because of what the case is about, those cases end up in federal court. An example of one type of case where the federal court has subject matter jurisdiction is what's called diversity. And the idea behind this, and this is another one of these matters embedded in the Constitution, is in the old days, the theory was if I live in, let's go with the 13 colonies, if I live in Virginia and I sue you for something you did in Virginia, but you're from Massachusetts, then I'm going to have an unfair advantage, a home field advantage, if I bring my lawsuit in state court in Virginia, even if it concerns something that doesn't have what's called federal question jurisdiction. So the idea is if we're from two different states and I sue you in my state, at a certain dollar value, at a certain magnitude of importance measured in dollars, you can then remove the case to federal court, where you would have a more fair system, presumably not a hometown advantage by having the case in federal court. So that is diversity jurisdiction. The other area of subject matter jurisdictions for federal courts specifically is what's called federal question jurisdiction. And the clearest example of this would be some of the cases we've discussed previously on this podcast. If you're dealing with federal constitutional issues like due process under the 14th Amendment, that's a case that only can be in federal court. It's called federal question. Another example of such a case is there are federal statutes that exist to protect people from employment discrimination. And the statute, being a federal law, creates jurisdiction in the federal court as opposed to a state court. So that case has to be in federal court. And that is the particular jurisdiction we're talking about. That is the distinction. I mean, your typical personal injury claim, unless it's being brought against a company or an individual that lives in another state and just happened to be visiting Texas when they injured you, that's going to be in state court. If you're fighting over a breach of contract because you paid for goods or services and they were not given to you, that's almost always going to be in state court. The
Right.
federal court cases are going to involve those rare cases worth a lot of money. The limit right now is $75,000, where you have two people from different states or claims against the government. That's one I haven't mentioned. If I want to sue the federal government for something I did, it gets to have the case in federal court. Those only are in federal court. So that is subject matter jurisdiction.
All right,
No,
so let me just
yeah,
pause for a minute so I can clarify something. So we're talking about personal jurisdiction, we're talking about subject matter jurisdiction. So what you've done is try to explain that to my listeners and to even clarify for me what's going on.
yeah. And I
Um,
would point out some cases could be brought in both courts. So then it's just a choice of federal court or state court.
okay, so what example would there be for it can be brought in both courts?
There are certain types of cases like the Fair Debt Collection Practices Act that can be brought in federal court or state court. There are, at least in Texas, there are some statutes that likewise prohibit employment discrimination. And perhaps if I'm a plaintiff and I want to be in state court, I only rely upon and reference the state causes of action for employment
Okay.
discrimination.
Okay, got you. Well, that explains something for me too, because there have been situations that I've been in over the years where some of my friends have had to file for inappropriate treatment but in employment and so forth. So that helps a lot. So what I want to do though is I want you to be much more specific in relationship to this case about the jurisdiction that happens in federal versus state and show me how this particular case, where it started, where it was placed and things like that. So we can have an understanding of the jurisdiction in this particular case we're going to talk about.
Okay, and the particular case is Chevron v. Plaquemines Parish, Louisiana. And by way of background, there is a statute, there is a Louisiana law that permits the parishes in Louisiana, the Louisiana equivalent of counties, to file suit for environmental damage occurring in that parish. And in particular, with the Plaquemines Parish case, it deals with coastal erosion. So what you had is, and this is just one of a collection of cases. I think I don't have the case open in front of me, but I seem to remember that 42 of these lawsuits were filed across southern Louisiana, and many of them were in the Eastern District, which is going to be the New Orleans area from a federal standpoint, but many of them were also in, from a federal standpoint, the Western District, more towards Lafayette and Lake Charles. But they were filed by the coastal parishes in state court looking to enforce a state law that would allow them to collect damages from private actors for taking certain actions that harmed the environment in Louisiana. And the parishes would choose to file in state court because, one, the origin, the creation of their right to collect damages was a state law.
Right.
But the other thing is, if I'm Plaquemines Parish and I'm suing for money for my parish, it would be like Harris County, where Houston's located, suing in state district court to say, look, we need money for the county, and this was going to go into the county coffers, and this will benefit everyone. Well, if I'm going to do that, of course, I'd like to file suit in my own parish or county because I think the public is going to take a much better view of that as opposed to, say, filing the case up in Dallas or, for that matter, filing it in federal court where I could end up with a lot of people on the jury that are from uh, Montgomery County or Waller County or other places and really don't care about fattening the coffers of Harris County.
Right. Right.
And that really reveals one of the most important decisions that you can make when you file a lawsuit. More often than not, I'm defending people. I'm not representing the plaintiff. But one of the most important decisions is where you bring the lawsuit. And that touches on something called venue and also something called jurisdiction, as we're discussing. If you can bring a case in state court, there are a lot of advantages that a plaintiff would see themselves having in state court.
Hmm.
The laws are often more beneficial to them, at least where we live. The Fifth Circuit, which is Louisiana, Mississippi, and Texas, the appellate court that would hear a decision or a judgment from the trial court is generally viewed as being very conservative. And that doesn't just go with respect to constitutional issues, it also goes with respect to damage awards. They tend to um, um, be a bit more reticent to allow really large damage awards to stand as a general rule. Not, it's not something that's across the board, but more often than not, you want a conservative court. Another benefit, if I'm a defendant, to being in federal court as opposed to state court, the plaintiff typically wants to be in state court. You're picking people local to you. But in state court, I have a lot more control over picking a jury here in Texas.
Right.
There's a process called voir dire where you will have people called in that might be on the jury. And the lawyers in state court in Texas are given a lot more leeway in the questions they can ask people that might be on a jury so that they can identify people that they do not think are going to see the case favorably to their client. And then you use strikes to get those people off of the jury. In state court, I have a lot more control over that as a lawyer. In cases I've tried in federal court, the judge tends to take the lead on picking the jury. I've heard of some judges where they exclusively pick the jury. I've been in courts where the judge allows the lawyer to ask questions, but the questions are very limited in what the judge will allow. And there are some federal courts where you have to submit your questions to the jury in advance in writing, and the judge will ask that. So the level of follow-up questions you might have to expand on people's opinions is limited. The long and short of it is the federal judge often gets to pick the jury they want as opposed to me getting to pick the jury I want. And
Okay.
that's
Let me ask you another question.
okay.
Can can a case like Chevron start in state court and then they move it to federal court and they could even move it to the Supreme Court. So how would it move from state to federal to Supreme? What would have to be the dimensions or the dynamics around the case that would move them like that?
It, and it's quite often it's called removal. And I've got several cases now that began in state court and are now in federal court. Someone files suit in state court claiming jurisdiction in state court. I, as a defendant, look at the case and say, well, I don't really like this judge, or I don't really like the county in which we're located. So if there is a basis for federal jurisdiction, more often than not, it's diversity. I would then try and remove the case to federal court, and it's called a notice of removal. I file that
Okay.
with the state court, and that stops things in state court, and then I file the notice in the federal court to which the case should go, along with all of the filings that currently exist in state court. Basically, I file the removal petition in state court, and then I refile the lawsuit in federal court, claiming that's where it should be. And that has happened in the Chevron case twice. And what that case reveals from a standpoint of picking your jurisdiction is Plaquemines Parish desperately wants to try the case in Plaquemines Parish, and the energy companies desperately want the case in a federal court in New Orleans, where the majority of the jurors presumably are not going to be in Plaquemines Parish, dealing with a lawsuit that's going to fill Plaquemines Parish's coffers if it's successful. The first attempt at removing the case to federal court by the energy companies, and this is a lawsuit that was filed over 10 years ago, was they claimed that there was admiralty jurisdiction. And that is one of these federal question issues where there are particular statutes that govern lawsuits in navigable waters that, are not seen as really being part of a particular state. So they removed it to federal court on that basis, and the federal district court judge said, no, this is not an admiralty case, and sent it back to state court. Or may have said, well, it's an admiralty case, but these are the types of cases that allow you to choose whether you want state or federal court. Certain cases involving acts on the high seas, Seaman, Jones Act, admiralty
Mhm.
cases, some of them can be in state court or federal court at the plaintiff's choice. But one way or the other, the case goes back to state court. Then what happened is, and I'll point out here generally, I can't remove a case to federal court and go directly to the U.S. Supreme Court. The U.S. Supreme Court is what's considered to be the highest court of appeal, which means they're only going to decide questions that are first answered in a lower court,
Right.
with
Right.
rare exceptions like where they have exclusive jurisdiction. This is not one of those.
Okay.
So the case ends up back in state court, and Plaquemines Parish produced an expert report. And the Louisiana statute, to get into a little more detail on it, it primarily involved actions taken along the coast or in coastal communities after, I think, 1982. But there are certain actions before 1982 that you could still file suit for damages on. If the actions were illegal, things of that nature, they would not be seen as grandfathered in. And the expert report focused in particular on high levels of production in the 1940s along the coast by several of the energy companies. And when they did that, Chevron, who over the years has acquired other companies, looked at the production efforts of some of the companies they've acquired. I think the two in particular were Gulf Oil and the Texas company, or as we all know it when we used to pull into a gas station, Texaco. That the production that was being done at that time was being done to supply increased oil to refineries to produce aviation fuel for the U.S. Army for World War II. So what Chevron then did is they said, well, there's a statute that allows us to remove lawsuits that are against a federal officer or someone acting under a federal office or officer pursuant to what they've directed the individual to do, the person to do. And here we were directed by the U.S. Army to increase the production of aviation fuel for the war effort. In order to increase the production, we needed the oil. So for that reason, we increased the production to the levels that you're saying violated the law and were improper, and that give the parish the right to recover damages from us. And the statute that allows, if I'm acting as a FBI agent and I'm sued for my actions as an FBI agent, then under that statute 1442, I can remove the case from state court to federal court. You're claiming I injured you, and I'm saying, well, yes, I did it though, acting as an officer for the federal government. So I remove the case to federal court. That's a very simple example. The Chevron example is a bit more complex or convoluted. But anyway, for a second time, Chevron removed the case to federal court in New Orleans. And there the judge looked at the case and looked at the statute and said, no, the contracts you're talking about with the Army were for producing aviation fuel at a refinery. They did not require you to produce the oil, to drill and remove the oil from this specific area. So at the district court level, the trial court level, the judge said, I'm remanding the case. And Chevron then appealed to the Fifth Circuit and said, look, we believe that this case should be in federal court under this statute because we were doing this for the U.S. Army to increase the production of aviation fuel. And when you first go to a federal court, to an appeals court, you'll have a three-judge panel that'll decide the case. And they decided the case and said, no, this is not something that you can remove to federal court. And this is where we get into the language of the statute. The particular
Okay.
statute, yeah, the particular statute 1442 used to read differently. It was an officer and it involved actions by the officer. The statute was changed in 2011. And as both the majority opinion from the Fifth Circuit and the Chevron v. Plaquemines Parish case point out, as does the lone dissenting justice, in 2011, the statute was changed so that the language involved related to, it was not just actions by the officer, but it also involved lawsuits for actions related to the federal action. So related to is broader language.
Right.
And that's ultimately what gave rise to them removing the suit. And that was the question that was presented to the panel and then to the Fifth Circuit, I think as a whole. Hold on just a second. I'm going to pull it up so that I can look at it and remind myself whether or not this was an en banc decision. I believe that it was. En banc being just a fancy legal term or a Latin term meaning the entire court and not just a panel. So give me just a second.
Sure. One of the things I enjoy working with you about is you're very careful in the way you research these cases, and you always try to give the best presentation you can about the case. So, one of the reasons that I chose you as an attorney I wanted to work with is so that my listeners would get the best information they could possibly get. And that's the reason
Okay.
we're pausing for a moment.
Oh, okay, yes. And the deal is this was just in front of a panel, meaning three judges, or
Right.
three justices in the Fifth Circuit. So the majority opinion went through that change in the statute and the language. And what they said is the meaning of that is the lawsuit based on some action that is connected or associated with the contract awarded by the federal government. And there, the majority panel said the production is not connected or associated with the contract. And the example that the judge writing the opinion for the majority panel gave is he the majority panel, he wrote that while you were required to produce increased amounts of aviation fuel that would have your refinery operating at full capacity, the contract did not require you to drill for and produce your own oil that would be used to make the aviation fuel. You could have bought it from other producers on the open market and still made the aviation fuel. So the fact that you drilled for it and drilled and produced at excessive levels in Plaquemines Parish was not connected or associated with the contract to provide the aviation fuel. You had one judge that dissented, and his dissent, he said, well, I see related to as not connected or associated with. I see it as much broader. To me, relation uh, or related to means there just has to be some relation to the federal contract. And to me, the fact that you were using hydrocarbons produced from Plaquemine Parish at these excessive levels, that is some relation to a contract with the U.S. Army that required you to produce more aviation fuel. So I think this case should be in federal court. And when I was saying earlier that we would get into an English language, ultimately the dispute here amongst three highly educated jurists is the meaning of related to. You have two judges that say related to is connected or associated with, which is here, and you have one judge which says some relation to, which is here,
Okay.
which would
Much
have
larger. Much
much
larger.
larger. And if his opinion were the majority, or if the Supreme Court, which has decided to take the case, goes with the view of the dissent, the effect of that is going to be that it will greatly increase the number of cases that end up in federal court. You're just going to have a lot more cases that end up in federal court because related to is such broader language. And there's an example that the judge gives in the dissent where he says, true, the contracts did not specify where or how defendants should acquire the massive amounts of crude oil needed to fulfill their avgas obligations, nor, I suppose, did the contract specify where or how defendants would acquire the additional human labor to increase output at the refineries. And the reason I focus on that is there's quite a lot of litigation that happens in Houston in particular, where you will have contractors working at a refinery or a chemical plant down here doing turnover work, where they are not employees of the refinery, but nonetheless they're working on the refinery when they are injured. And if
Right.
you take the example that I think it's Judge Oldham uses in his dissenting opinion, the majority opinion, what you have there is a circumstance where if the if the energy companies engaged and hired contract labor for the increased production efforts, then somebody slips and falls in the plant where they're not an employee and under workers' compensation law, then that would be a federal lawsuit, regardless of the dollar value, because they are now performing work that is related to the company fulfilling a government
Right.
contract. And to take it out of the specifics of the Chevron case, the Chevron v. Plaquemines Parish case, I'm willing to bet that pretty much any refinery we've got here on the ship channel is probably making or producing gasoline, if not aviation fuel, some other type of gasoline that perhaps they're supplying to a depot for the Army or the Air
Mhm.
Force, or that's going into, uh, you know, marine vessels that are not nuclear, or that might be directed to the federal surplus. And to the extent you have refineries with current contracts with the government for any one of those things, providing fuel for, the forestry service trucks, then the fact that an injury is occurring at their refinery when they have a contract with the federal government to produce some fuel for it means now any injury on the refinery's property would have some relation to
Mhm.
work they're doing for a federal department or federal office. And that's what I mean by the fact that the dissent's opinion would make this jurisdictional issue much broader.
Well, and I think we don't want to overload we don't want to overload the federal courts. So, what do you think is going to happen in this case between Chevron and Plaquemine Parish?
Well, I'll get to that in just a second, but I want to bring this in particular to Plaquemine Parish. There's one case that's discussed in there that I haven't touched on, and it's a earlier Louisiana case,
Right,
Latolay, and it involved a shipman who was exposed to asbestos insulation on a naval ship that was retrofitted or repaired in the Avondale shipyards in New Orleans in the 1960s.
right.
And there, his case for asbestos exposure was removed from state court to federal court because they were claiming the shipyard was doing this work on a Navy ship. And in that case, the the Fifth Circuit, the old statute, it used to be that in order to remove the case, there had to be a causal connection. Where when I was talking about the majority opinion and the dissenting opinion, causal connection is this. I mean, it's literally the injury arose out of that person's work on the government
Hmm.
contract. It's that narrow. So what in Latolay the court did was they said, well, the related to means we have to broaden the scope, and they went to the connected or associated with language as opposed to the causal
Okay.
connection language. Now, ultimately, what happens is if I'm doing the work under a federal contract, in many circumstances, even though I am a private company, I now enjoy what's called quasi governmental immunity. If I'm doing something at the direction of the government or for the government, then I enjoy the same immunity the government enjoys for the work that I'm doing. And in Latolay, when the it was an en banc decision. When the entire Fifth Circuit decided the case, they then pointed out that the Avondale shipyard would be immune from this type of lawsuit in federal court, or maybe immune. I think they may have remanded that for the district judge to make that decision. I can't recall offhand. But the point is, by having the case in federal court and by determining that the injury, was related to a federal contract, there was now governmental immunity that attached to this issue.
Right.
And that's
Okay.
why that's why you brought this case to my attention is you forwarded to me an article pointing out that with many of these environmental cases that focus upon um, accidental discharge or overproduction and erosion of the coastline in Louisiana, where I grew up, the concern is if the cases are now something that are seen as being an injury related to the performance of a government contract, then suddenly Chevron or ExxonMobil or BP enjoys governmental immunity because the work was being done related to a government contract. So that's why a lot of people are concerned about what I would say is a
Right.
simple jurisdictional case. No, your question wasn't that, but I think that's a precursor to me answering your question, which is, what do I think the Supreme Court will do? And I would say my prediction of what they'll do is maybe slightly better than a WAG, a wild ass guess. But by way of background, when the statute was changed in 2011 to allow the removal of cases related to governmental work, what happened was you've had four courts, including the Fifth Circuit, which have now gone to this broader connected or associated with the contract scope. There are another four courts that, even though the statute was changed in 2011, they're still using this narrower causal connection language. The
Hey, now wait a minute. Wait a minute. Before you answer my question, I want you to do something because I hadn't realized what I did earlier in asking my question. In cases where these four courts are considering it causal, can you compare that? Because it seems to me if it's connected to a federal contract, then it's going to be really hard for a parish to get any kind of compensation. But if it's causal, then a parish would be able to get some kind of remediation or fun,
well,
yeah.
the remediation is ultimately the end result, the symptom, if you will. Ultimately, the question is still one of jurisdiction. And with the causal connection for removal, for getting the narrower scope for getting the case in federal court, that means more cases end up in state court.
Okay.
Um, so, the causal connection was a test that was crafted under the statute pre 2011, before the
Okay.
related to language was added. The thing is, even though the language of that statute has changed, you've still got some federal appellate courts, including, I believe, the court in, I think it's in St. Louis, Missouri, that still apply that narrower standard. The Fifth
Okay.
Circuit now applies a broader standard, the connected or associated with. I would point out that the only judge that I've seen that is going with the some relation to test is Oldham, the dissenting judge on the panel in the Chevron case. Now, the
Okay.
concern amongst environmentalists is if the Supreme Court goes with the some relation to test, then all of this environmental litigation is going to die because of the federal immunity that would attach to the
Yeah.
energy
And that's what I'm,
component.
yeah.
So, what I think will happen is uh, I think the Supreme Court is going to be reticent for the perhaps tsunami of cases being removed to and remaining in federal court if they approve the broader some relation language. What I think we've got here is a classic case of a circuit split, which is quite often the types of cases that end up on the Supreme Court when you're dealing with non constitutional issues, where ultimately the court has decided we've got four courts of appeal that are saying the law is X and four courts of appeal that are saying the law is Y. We need to decide what the law is for all of the courts of appeal in the United States handling federal cases. And I think what the Supreme Court is going to do is they're probably going to adopt the middle approach, which acknowledges that the change to the statute in 2011 was meant to broaden the scope of cases that could end up in federal court where you're doing work pursuant to a government contract, but that we didn't mean to make it so broad that literally somebody, driving a truck by the refinery that gets hit by a tanker that pulls out that happens to be carrying gas on its way to a military base suddenly becomes a federal case because of a motor vehicle accident on a you know a public road, which is
Right,
what the
right,
some relation to could arguably result in. I think they'll
right.
go to that middle ground where they're looking for a more direct relationship, but not something that it arises directly out of the contract. A closer relationship, but not that immediate smaller scope. So
Okay.
ultimately, what I'm saying is, I think the U.S. Supreme Court is going to say, um, we're adopting the view that the majority did in the Chevron case, and we're making it clear to the other four courts of appeal that going forward, the scope of cases that can be removed is now broader than the old causal connection test.
Right.
I think they'll adopt the middle ground, but there are no guarantees on that. And the reason I think that is because I've seen other cases where the court has been asked to broaden the scope of federal
Mhm.
jurisdiction. One of them in the legal malpractice realm was you had some lawyers that tried to remove an intellectual property legal malpractice case to federal court about 15 years ago, arguing that because the underlying dispute involved a federal question, which is patent law, that the malpractice suit should also be in federal court. And in that circumstance, where the U.S. Supreme Court was offered the opportunity to expand the subject matter jurisdiction of federal courts, they said, we're not going there. We're not going to make it that broad. Your case is a simple negligence case under state law. It doesn't matter that the underlying case dealt with federal law. And I would say that's a good metaphor for connected or associated with as opposed to some relation to.
Yeah.
So
Yeah.
I think that case might be a parallel that shows what the current court will do as opposed to what the court did some 15 years ago, when granted there were a lot of different people on the court at that time.
Right. Well, and I think you've given an explanation for that. Now, of course, the parish would like to have it in state court because they have a huge amount of money that they would get.
Yeah, and I believe the opinion touches upon the fact that of the 42 cases that had been filed, one of the cases had already resulted in like a $750 million or $740 million award. And the concern of many people is that if suddenly these are all federal subject matter jurisdiction cases, then if the state court lacked the jurisdiction to decide the case, that judgment suddenly goes away. And under federal law, if the energy company has immunity, you will have some judgments that have already been rendered that suddenly will disappear. No, some of the energy companies have just settled. They've looked at it and said, well, as opposed to Richard Wilson, who doesn't charge quite as much, we're paying $1,500 an hour for lawyers out of DC and New York and Chicago and Los Angeles, and even that much for some lawyers in Houston. And if it's going to cost us, $50 million to try this case, well, hell, let's just go ahead and pay $50 million to the
Yeah.
parishes to settle it. So there
Right.
have been some settlements
Okay.
already,
So
and
another,
those would remain in place because now you've got an enforceable contract between the parties. But the cases that have resulted in judgments, there's some concern that those judgments would be at risk, despite the size of the award.
okay, so one of the things I'm going to ask you, because I don't know these parishes very well. So what does Plaquemine Parish say has been most detrimental to their area based on the things that Chevron has done or some of the companies they've bought have done? What is the damage?
That's an interesting question, and I can answer that not as a lawyer, but as someone who spent the first 21 years of my life in
Yeah.
Louisiana, being born in Morgan City, even. The probably the biggest source of damage has less to do with the actual production and taking the oil out of the ground, but more to do with dredging, which is creating deeper and wider channels to
Right.
get, you know, boats into these areas so that the companies can drill or can do work around the well or can lay pipelines to get the oil from these wells back to a collection facility where the oil can go to a refinery. The result of the dredging is by creating the deeper and wider channels, salt water has gone further into the state of Louisiana. It is, where it used to be limited very close to the coast, it can now follow these wider man-made canals or channels much further in. And what the
Hmm.
salt water has done over time, and I'm not an environmentalist, but in layman's terms, is it's killed a lot of the vegetation that holds the soil
Right.
in place.
Right.
And as a result, the Mississippi River, the Atchafalaya River, as they flow down to the Gulf, they're taking more of the soil away. Or what happens is the waves from the Gulf come in further and pull the soil away. And then they're able to go in even further and pull more soil away. And I mean, I look at topographical or satellite maps of Plaquemines Parish now, and it's a shadow of what it looked like back when I was in
Right.
elementary school. And it's largely because I would say it's more so because of the dredging operations. And that also creates what I think would be an interesting complication with the case, even if it were in federal court, which is that, okay, well, we're only talking about a small amount of damage due to the increased production. And you're then looking at having to quantify, well, what might be related to the federal contract, and what do we have that we can completely divorce from the federal contract, so that it still state law would still apply. So you then
Right.
end up with even more money being spent on lawyers and even more complications in what was already a very, very complicated case.
Right. But the thing of it is that if they could separate things out, then the plaintiffs would have a better chance of building their case to say, well, this is separate from the federal contracts, so it needs to come back to state court so that we can try what has really happened to our environment.
What the problem there is if one part of the case can be removed to federal court under something like this, then what you have is the entire case against Chevron goes to federal court because
Oh
the
gosh.
courts
Okay.
the courts despise having parallel cases running in two different courts. And the reason courts despise that is one, it's seen as an economic waste where we're
Right.
devoting government resources to a case in state court and a case in federal court. But the other concern that the courts have is sometimes the courts look bad if one court decides the case in favor of the plaintiff and the other does not. You can have what are called competing or contrary judgments. So, to prevent that, if a case can be removed, you don't just get to remove this small part of the case
Okay.
that's related to federal question. You remove the entire case because of that
Okay.
single federal question.
Okay.
Sorry that I'm moving my hands around like this, but
No, 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 but it makes more sense as you move your hands around. Well, to me, I think it's a very important case because there could be some real ramifications for county and states where there is damage done. So
even
if
private
you,
landowners.
yeah, and that's what concerns me too with private landowners. So what do you think that you would recommend as a lawyer when and I haven't asked you this before, and I didn't warn you I was going to ask you this. But what would you recommend as a lawyer to a private person or to a county or something to say, if you're going to do business with an oil company, what all do you need to cover in your contract so you can protect yourself and protect your environment?
Well, in these circumstances, I don't know that we necessarily have the parishes doing business with the federal government. I mean, with an oil company. What we have is a circumstance where the oil company has arguably entered into leases with private landowners. And as a
Okay,
result of
okay,
that, they've undertaken actions which have resulted the parish as a whole, resulted in damage to the parish as a whole. So,
okay.
there's really not much the parish can do in that regard.
What would you, but what would
what
you
I could,
recommend? Yeah, but what would you recommend to then a private owner
well,
to?
yeah, and what I could foresee from a standpoint of the private owner, a lot of them, have certain protections, and you have had quite a wave of private lawsuits involving remediation to private land in Louisiana. And I know that I've heard lawyers in Louisiana complaining about it because the way the law was drawn, the Louisiana statute was drawn, you would have a private landowner that would buy land that had been damaged by, say, a spill, and they sue for remediation damage, and they get the money, and then they sell the land, and someone else comes in, and the prior owner hadn't performed the remediation after they got the money. So the energy company is getting sued a second time by a second owner wanting damages for the same remediation they've already paid for. Um, but the short answer to that is, from a private landowner standpoint, with the broader damage, there's not really much you can do. I mean, with most of these leases, they're, with private entities, they're going to involve these API leases, American Petroleum Institute, these form leases where the only thing you really negotiate on is a bonus payment and the amount of the royalties you're receiving.
Right. Okay. Well, we shall see what happens. And we will certainly, when we hear some, further action taken, then we'll be certainly included, even though it may not be our subject matter, so we can keep our listeners up with what it is. Because I think Chevron is going to make a major difference. And I think
No,
that, yeah,
I will point out this, if I were a parish or a county filing suit, I would probably, even though my damages might be larger, if I can determine what amount, where the oil was going and what actions caused the damages, if I could isolate what I sue for to be for things that have no connection or association with a contract for the government, that would allow
right.
me to keep the case in state court. It literally might involve excluding some damages that were caused simply to remove the possibility of the case ending up in federal court. Because arguably, had the
Good.
expert not included that one opinion about increased productions in the 1940s, this case might have continued in state court in Plaquemines Parish.
Okay, then you've answered my question because
Okay.
that's what I wanted to know, how to keep it in state court. And so
Yeah.
you've really done a great job. Okay, Richard, I think we have done the best we can with this. So I'm just going to say to my listeners, I appreciate you immensely listening to us. You have my connections, so you can certainly make comments to me about what Richard and I are doing. We'll be happy to hear any responses you have from us, and we'll be back. This case is going to be, I'm going to put it out the first week of January. So we shall see what happens. And I really thank you so much. And I'm going to stop us talking about this. So thanks so much, Rich.